What is going on, everyone, and welcome back to Firearms Law Advisor, the channel where we break down the laws that directly impact your Second Amendment rights so you're never caught off guard. I'm your host, and if you're new here, make sure you stick around because today's video is one that every gun owner, every 3D printing enthusiast, and frankly, every person who cares about constitutional rights needs to hear. Before we get into it, and I promise this one is going to be worth every second, I just want to say a massive thank you to this incredible community we are building together. We are sitting just 500 subscribers away from hitting 2,000 subscribers on this channel. That is huge for us. So if you haven't subscribed yet, please do it right now. Hit that button, it costs you nothing, and it helps us keep bringing you this kind of coverage. Every single subscriber genuinely matters to us. All right, let's get into the story. Now, if you've been following California's legislative session this year, you already know it has been one of the most aggressive years for anti-gun legislation in recent memory. Bill after bill has been pushed through the California state legislature, and the supermajority has made sure that almost nothing stands in the way. And I want to be very clear here. It is not for a lack of opposition. Some of the most knowledgeable, most dedicated people in the Second Amendment space have been showing up at these committee hearings, providing expert legal testimony, constitutional analysis, the works. Organizations like the Gun Owners of California, Gun Owners of America, the CRPA, the NRA, all fighting hard. And still, these bills keep moving. That tells you just how stacked the deck is right now in Sacramento. But here's the thing. One particular bill, a bill that we have been tracking very closely on this channel, appeared to finally be running out of road. It looked like it was finished, done, over. And then, in one of the most frustrating last-minute political moves I have seen in a long time, it was suddenly revived, amended, and pushed forward, all in a single day. That bill is AB 2047, and today we are going to break down exactly what it is, what just happened, and what this means going forward. So let's start with the basics for anyone who might be hearing about this for the first time. A B 2047 is what most people are calling the 3D printer bill, and when you hear the details, I think you'll understand why this is being called one of the most dangerous and constitutionally problematic gun bills California has introduced in years. Here's what this bill would do. It would essentially require that any 3D printer sold or used in California must have state-approved software installed on it. This software would be designed to monitor and control what you print. Specifically, if the software detects that whatever you're trying to print looks anything like a firearm or a firearm component, it would block that print entirely. The printer would refuse to do it. And it doesn't stop there. The bill would also create what is essentially a roster system, similar to California's handgun roster, but for 3D printers. So you couldn't just go online, find a printer you like, and buy it. No, you would have to choose from a state-approved list of printers, and the only way a printer gets on that approved list is if it has this anti-gun detection software built into it. Now think about what that means in practice. California would effectively be controlling access to a technology based on what that technology could theoretically be used to produce. And beyond just the Second Amendment implications, there is a massive First Amendment issue here as well, because 3D printing files, the G-code files that tell a printer how to move, those are a form of digital code, and code, under established federal case law, is considered protected speech. The Ninth Circuit Court of Appeals ruled that code is speech in Bernstein versus Department of Justice. The Third Circuit reached a similar conclusion in Younger versus Daley. So this bill isn't just going after your right to bear arms, it's going after your right to free expression as well. Now here's something really important that I think gets lost in the political noise around this bill. The technology that California is demanding doesn't really work the way California thinks it works. And I want to spend a moment explaining this because it matters. A lot of people, and honestly, a lot of legislators, picture a 3D printer like it's some kind of scanner or camera-based system, as if the printer looks at an image and decides whether to print it or not. That's not how it works at all. A 3D printer operates off what's called G-code. G-code is essentially a series of movement instructions. It tells the printer's head where to go on the X-axis, the Y-axis, and the Z-axis. There are no images involved. There's no visual recognition happening. The printer has no idea what the finished object is going to look like. It's just following a set of directional commands. So the idea that you could install software that looks at a print job and says, hey, that might be a firearm component, block it, from a technical standpoint, that is is extremely difficult, if not effectively impossible, to implement in any reliable way. The bill is built on a fundamental misunderstanding of how the technology actually functions, and the people who understand this best have been saying so loudly in committee hearings. One of the most compelling expert witnesses on this was David Tobin, who is the executive director of the Community Manufacturing Initiative and also runs a YouTube channel called 3D Printing Nerd, which has nearly 700,000 subscribers. His testimony was some of the most detailed, credible, and technically sound opposition testimony you'll hear, and it still wasn't enough to stop the bill from moving. So let's talk about how we got to where we are right now, because the sequence of events here is important. A B 2047 had been moving through the legislative process at a remarkable pace. Committee after committee, it kept passing. Even with all the opposition testimony, even with constitutional arguments being made in real time, the votes kept going in the bill's favor. Then it reached the Appropriations Committee. Now, the Appropriations Committee is essentially California's fiscal responsibility checkpoint. Its job is to examine whether a bill would cost the state a significant amount of money to implement and operate. If it would, the committee can place the bill in what's called the suspense file, which basically hits the pause button on that bill and flags it for further review. And that's exactly what happened. On May 13th, AB 2047 was placed in the suspense file, and for a brief moment it felt like a real win. Because here's the thing, there is a deadline for bills in the suspense file. They have to be pulled out of suspense and acted upon before a specific cutoff date. In this case, that deadline was May 15th. If the Appropriations Committee didn't vote to move the bill forward before that deadline, it was done, at least for this legislative session. As of the evening before that deadline, AB 2047 was not on the committee's agenda. It had not been scheduled for a vote, and that meant it was effectively finished. And then the floor dropped out, because on the very last day, with hours to go before the deadline, the bill's author pushed through a series of amendments and had AB 2047 pulled from the suspense file. Just like that, in one move, a bill that appeared dead was suddenly alive again. The Appropriations Committee passed the amended version, and it is now headed to the Assembly floor for a full vote. Now let's talk about these amendments, because they're actually interesting from a strategic standpoint. From what has been reported, the amendments made the bill's implementation requirements significantly more difficult, almost impossibly so, to actually carry out. And ironically, they also made the bill cheaper to implement, which is probably exactly why the Appropriations Committee was willing to let it through. The fiscal objection was addressed, even if the practical and constitutional objections very much remain. So what are we left with? A bill that is constitutionally questionable, technically unworkable, and yet politically alive. It's heading to the full assembly, and if it passes there, it goes to the governor, and if the governor signs it, it becomes law. That's how close this is. Now I want to explain something that is really important context for understanding why the timing here matters so much. California operates on a 2-year legislative session. Right now, we are in the second year of the current session, which runs through the end of this year. Next year, a brand new session begins, running through 2028. Here's why that's significant. If AB 2047 fails to reach the governor's desk before the end of this session, if it dies on the assembly floor or gets vetoed or fails in any way before the deadline, it cannot simply be brought back next year as the same bill. It's not like it gets to carry over. The authors would have to start completely from scratch. New bill number, new introduction, new committee process, new hearings, new votes, the whole thing from the very beginning. That means every point of resistance between now and the end of this session is absolutely critical. We have a real opportunity to end this particular bill for good, and that should motivate anyone who opposes it to make their voices heard right now while there's still time. So what does all of this mean for you? If you are a California resident, now is the time to contact your assembly representative. Let them know you oppose AB 2047. Let them know that you understand the constitutional issues with this bill. Let them know that this is not something you are willing to accept quietly. Calls and emails to assembly members genuinely do matter, especially on a bill that is moving as fast as this one is. If you're not in California, this still matters to you, because legislation like this doesn't stay in California. We have seen it time and time again. Bills that get introduced in one state become templates for other states. If AB 2047 becomes law and survives legal challenges, you can expect to see similar proposals showing up in other legislatures across the country. The fight in California is, in many ways, a preview of the fights the rest of the country may face down the road. And if you want to support support the organizations that have been doing the heavy lifting on this, fighting in the hearings, providing legal analysis, funding the legal challenges. Look into the gun owners of California, the CRPA, and the other groups that have been in the trenches on this bill. Their work is what makes opposition like this possible. All right, that is where things stand with AB 2047. We are going to be watching this very closely as it moves to the assembly floor, and we will absolutely keep you updated with any new developments the moment we have them. So, if you are not already subscribed to Firearms Law Advisor, this is your reminder. Hit that subscribe button right now so you don't miss our next update on this bill or anything else that impacts your rights. And as I mentioned at the top, we are just 500 subscribers away from 2,000. That is such a meaningful milestone for this channel, and we could not do this without every single one of you who watches, shares, and supports what we're doing here. If you found this video valuable, share it with someone who needs to hear it. Drop a comment below and tell me what you think about AB 2047 and what California is doing. I read every comment, and I genuinely want to know your thoughts. A huge thank you as well to everyone who testified and fought against this bill: David Tobin, Adam Wilson, the gun owners of California, Gun Owners of America, the CRPA, the NRA, and everyone else standing up in those hearing rooms. The fight is not over, and neither are we. Until next time, stay informed, stay engaged, and stay ready. I'll see you in the next one.